Welcome to the Tiger's Den. This is the voice of Cheryl, and I am Toothless Tiger. I'm going to bring to you tonight the 7 elements of jurisdiction. Oftentimes we hear about jurisdiction, but we really don't know what role it plays in our lives. Hopefully, after hearing these elements, you will understand that jurisdiction covers your very being as a full life breathing human being. An affirmative responsibility of any national or citizen is to adhere to and to enforce the principles embodied within the national constitution of his or her national government, nation state, and of society at large. This proposition embodies a primal rule in civilization and involves the duties and of citizenship. Constitutions are designed to maintain justice, peace, and harmony within a social order or body politic. Therefore, for directives in social duties and for general intersocial instructions, the advent of the universal-oriented science of government, that science is called civics, nationhood, citizenship, nationality, public service, politics, economics, and organized government in general constitute the science and discipline called civics. Constitutions are set forth to designate authority to those who govern and to delegate limits of authority to each and every specific office or seat. The Constitution does not give rights to the nationals and citizens. Constitutions are in place to preserve the divine and natural rights that already exist by natural and divine law. Constitutions are generally written to harmonize with nature's law and nature's God. Important aspects of the American Constitution that express the essence of its construct are demonstrated in Article 3 and Article 4. In relationship to the limitations of delegated authority, the readers and scholars will find that these articles strongly deal with the issue of jurisdiction, although the subject of jurisdiction is not limited to them. However, the intended preservation of the substantive rights of the people have been and are addressed with the established principles expressed within these articles. Supportive of these articles are the Bill of Rights, which is comprised of 10 amendments. These should be studied intently whenever any controversy arises concerning jurisdiction. Jurisdiction is the power to act, and more succinctly, the authority to do or to act in relationship to the limited authority assigned to a political seat, to a judgeship, to a court, to a trust, to any position in relationship to such exercises. The following relate to the secured rights of the people as embodied within the American Constitution. Whenever anyone is accused of a crime or charged with an offense, the following rules are to known, preserved, followed, and acknowledged as they are firmly in accord with the supreme law of the land. I need you to understand. Do not assume that attorneys or lawyers are working in the client's best interests. See Corpus Juris Secundum, CJS, Volume 7, Section 4, Attorney and Client. The attorney's first duty is to the courts and the public, not to the client. and wherever the duties to his client conflict with those he owes an officer of the court in the administration of justice, the former must yield to the latter. Clients are also called wards of the court in regard to their relationship with their attorneys. Do not assume that court officers are competent or legitimate. Corpus juris secundum assumes courts will operate in a lawful manner. If the accused makes this assumption, he may learn, to his detriment, through experience, that certain questions of law, including the question of personal jurisdiction, may never be raised and addressed, especially when the accused is represented by the bar. Sometimes licensed counsel appears to take on the characteristics of a fox guarding the henhouse. Now, I'm going to give you the 7 elements of jurisdiction. Accused must be properly identified. Number 1, the accused must be properly identified in such a fashion there is no room for mistaken identity. The individual must be singled out from all others. Otherwise, anyone could be subject to arrest and trial without benefit of wrong party defense. Almost always, the means of identification is a person's proper name. But any means of identification is equally valid if said means differentiates the accused without doubt. There is no constitutionally valid requirement you must identify yourself. See 4th Amendment and see Brown v. Texas 443 U.S. 47 and Colander versus Lawson 461 U.S. 352. The statute of offense must be clearly identified. Number 2, the statute of offense must be identified by its proper or common name. A number is insufficient. Today, a citizen may stand in jeopardy of criminal sanctions for alleged violation of statutes, regulations, or even low-level bureaucratic orders. Example, Colorado National Monument Superintendent's orders regarding an unleashed dog or a dog defecating on a trail. If a number were to be deemed sufficient, government could bring new and different charges at any time by alleging clerical error. For any act to be triable as an offense, it must be declared to be a crime. Charges must negate any exception forming part of the statutory definition of an offense by affirmative non-applicability. In other words, any charge must affirmatively negate any exception found in the law. Offense or nature of crime must be intelligently described, and that word is charge and not crime. Number 3, the acts of alleged offense must be described in non-presidential. Let me say that again because that's the wrong word. The acts of alleged offense must be described in non-prejudicial language and detailed so as to enable a person of average intelligence to understand nature of charge, to enable preparation of defense. The actual act or acts constituting the offense complained of. The charge must not be described by parroting the statute, not by the language of saying. The naming of the act of the offense describes a specific offense, whereas the verbiage of a statute describes only a general class of offenses. Fact must be stated. Conclusions cannot be considered in the determination of probable cause. Accuser must be positively identified. Number 4, the accuser must be named. He/she, the accuser, may be an officer or a third party, but some positively identifiable person, human being, must accuse. Some certain person must take responsibility for the making of the accusation, not an agency or an institution. This is the only valid means by which a citizen may begin to face his accuser. Also, the injured party, corpus delicti, must make the accusation. Hearsay evidence may not be provided. Anyone else testifying that they heard that another party was injured does not qualify as direct evidence. The accusation must be made under penalty of perjury. Number 5, the accusation must be made under penalty of perjury. If perjury cannot reach the accuser, there is no accusation. Otherwise, anyone may accuse another falsely without risk. Accused must be accorded due process. Number 6, to comply with the 5 elements above that are for the accusation to be valid, the accused must be accorded due process. Accuser must have complied with law, procedure, and form in bringing the charge. This includes court-determined probable cause, summons, and notice procedure. If lawful process may be abrogated in placing a citizen in jeopardy, then any means may be utilized to deprive a man of his freedom, and all dissent may be stifled by utilization of defective process. The essential elements of due process are notice and an opportunity to defend. Case law, Simon v. Kraft, 182 U.S. 427. One is not entitled to protection unless he has reasonable cause to apprehend danger from a direct answer. The mere assertion of a privilege does not immunize him. The court must determine whether his refusal is justified and may require that he is mistaken in his refusal. Kaufman v. United States, 341 U.S. 479, 1951 is the case law. The court must be of competent jurisdiction, properly delegated authority, DOAO. Number 7, the court must be one of competent jurisdiction to have valid process. The tribunal must be a creature of its constitution in accord with the law of its creation, i.e., Article 3 judge. Lacking any of the 7 elements or portions thereof, unless waived initially or unintentionally. All, and that word where I said initially, that's actually intentionally or unintentionally, all designed to ensure against further prosecution, double jeopardy. It is the defendant's duty to inform the court of facts alleged for determination of sufficiency to support conviction should one be obtained. Otherwise, there is no lawful notice, and charge must be dismissed for failure to state an offense. Without lawful notice, there is no personal jurisdiction, and all proceedings prior to the filing of a proper trial document in compliance with the 7 elements are void. A lawful act is always legal, but many legal acts by government are often unlawful. Most bureaucrats lack elementary knowledge and incentive to comply with the mandates of constitutional due process. They will make mistakes. Numbers beyond count have been convicted, without benefit of governmental adherence to these 7 elements. Today, informations are being filed and prosecuted by accepted practice rather than due process of law. Jurisdiction must be proved upon challenge. Jurisdiction, once challenged, is to be proven not by the court, but by the party attempting to assert jurisdiction. The burden of proof of jurisdiction lies with the asserter. The court is only to rule on the sufficiency of the proof tendered. See McNutt versus General Motors Acceptance Court, and that is 298 U.S. 178, 1936. The origins of this doctrine of law may be found in Maxfield versus Levy, 4 U.S. 330, 1797, 4 U.S. 330, Dow, 2 Dow, 381, 2 U.S. 381, 1 L period ED period 424. This is one of the things that you learned when you're taught under the Grand Chief Tariq Bey. He has done so much research, and he has provided us with this research. And then all you have to do is go and research for yourself. Again, never take anything that I say as the gospel. I would suggest to you that you would go and do some research. These are just keys to help you along your way. A lot of us have no clue about jurisdiction, and we may find ourselves in situations that we believe we have to hire attorneys for. Well, I am not an attorney and I do not practice law, and you may have to hire an attorney. But before you do that, do some research for yourself. And even if you hire an attorney, at least you'll understand what they should be knowing as they talk to you about representing you. Again, we live under the 5 principles taught to us by the Honorable Noble Drew R. Lee. And they are love, peace, truth, freedom, and justice. When we try to teach or share what we've learned, what we hope that we will gain is that you would realize that everything we do, we must do in respect and love for another. And so I hope that more people will start tuning in, if it's for no other reason but just to hear the subject matter and then research it for yourself. You never know when you may have to stand before the judgment seat of a judge, and you may be prepared to present yourself in such a way that you can walk away victorious, or you may be able to hold a decent conversation with the person that's representing you, and then you can get them to explain the things that you don't comprehend. Again, this is Toothless Tiger. I certainly appreciate you coming to the Tiger's Den. I ask that you're here. If you would hit the like button, if you would subscribe to my channel, and if you would share this video. Also, go in the comments and leave a comment. This is just what I've learned. I have no handle on truth. I'm just not afraid to share it. So if you want to learn what I've learned, then these are the keys that I used to get to where I am today. And I'm leaving the Tiger's Den. I thank you guys very much for being here with me. And I am hoping that I get better and better at my
This video was made for education and entertainment purposes only. There's no malice or ill intent from the content creator. So please Like, share, and subscribe. And have a great evening. Good night.